Hello, everyone. This is Attorney Claudia Pringles. Thanks so much for tuning in. I just have one little logistic question to move slides. How do I do that? The arrow. Looking for a little arrow to pop up, which. So this one here? The down arrow. Okay. Okay, so just a little bit about me. I'm a licensed attorney here in Vermont. I've also been involved with advocacy and helped get a few laws passed in the state, which I'm really proud of. I'm also a parent of two, including a daughter with autism, and she is now 20. And I also have a younger daughter who is 18, and her name is Lily. Down arrow. I've only done this 1,000 times, so every computer is different. So about my practice area, I started my law practice in 2008, focusing exclusively on special needs, estate planning, but I also do now, I've always done estate planning, but I haven't always told everyone I do estate planning as well. But part of special needs is at my office, we also do special education. So Attorney Matt Keister is going to be presenting. I believe that's next month. Janice just mentioned that information. I also do probate. I also provide trustee services. I have clients all across Vermont and outside of Vermont, and I love what I do. So I'm one of the few super happy attorneys that I know of. And down arrow. There we go. Okay. So, of course, I have to start with a disclaimer, and this webinar is just for information. It's not meant to be for legal advice. So if you do need legal advice for your own particular situation, make sure you go see an attorney. So here are some of the topics for today. I'm going to talk about the importance of planning, why you should worry about it or not worry about it. A document for planning purposes. I call it an IEP for life, but it's got a different name. We'll talk about government benefits, special needs trusts, ABLE account, guardianship, and then I'll take some question and answers towards the end. And as far as questions and answers, if you could just make sure if you ask a question, just to keep it short, because I do need to stop and read it, and you don't want to hear a lot of silence while I'm doing that. And just to keep it general, so not a specific question. So we are going to be talking about a beneficiary, conveniently named Ben E. Fisher. And we'll just use them as sort of an example of what can be done for planning purposes. So Ben just turned 18, and he has a disability, and he's in need of some support. Now, as far as disability for special needs planning, that's really a wide range. It could be someone with a mental health issue. It could be someone with a cognitive issue. It could be someone with a significant physical disability. For special needs planning, a lot of it's going to do with whether that person now or in the future is probably not likely to hold on to a full-time job. And therefore, they're going to need some finances, and they're going to need some services as well. For other people who may have disabilities that don't necessarily reach that level, there's different types of planning that we could do as well, and I'm happy to talk to anyone about that as well. So Ben lives with his parents, and he gets income from SSI. As most of you probably know, once a person turns 18, then they can be eligible for SSI because parent income and resources no longer apply to them. Ben has very limited personal assets, basically just his clothing, and he also qualifies for Medicaid. So what are some of the questions to think about as far as Ben? So we need to think about preserving public benefits. I want to move this over here a little bit. Who will make healthcare decisions, financial decisions? You know, where will Ben live? Who will be an advocate for him? while Ben's parents are alive, or at least one of them is alive, they can do a lot of this for him, help him make a lot of decisions and make sure he gets all the services that he needs and make sure he's taken care of and has a place to live and all that. So what are the options parents like Ben's parents have? First, an option is to do the ostrich method, and that's to not make any decision at all and not make any plans. That's never a good thing to do, and it's good to at least have some plan in place. I always say better a good plan today than a perfect plan tomorrow. They could decide to just leave Ben's share. So say they have 2 children. The other child is called sibling. So they could decide to leave Ben's 50% directly to Ben, and that's definitely not a good idea. And they could try to do their own special needs planning. They might have heard from somewhere that they can't leave anything to their son, so they might say, well, let me just disinherit him altogether and not leave him with anything. And of course, that is a horrible idea. They could leave money to siblings and say to their daughter, do us a favor, make sure your brother is taken care of, have a good day, and thank you for everything. These ideas just keep getting worse and worse, I think. So the first 4 are really bad ideas, but common ways that people try to solve some of these issues. A good idea is to establish a third-party S&T as a special needs trust for Ben, and I'll definitely talk about that. There might be a need to establish a different type of special needs trust if Ben has some of his own assets. In another planning, something to take into consideration is guardianship as well. So it's important to plan, because without a plan for someone with special needs, then the default is a horrible situation. I will tell you that every year at my office, I get at least a few phone calls from someone whose parents died. They might have died suddenly or not suddenly, and no planning was done. And now this person is about to lose all their benefits and they're panicking. Now, those people that come to me are the lucky ones. They have someone who can help guide them and say, hey, let's go call Claudia and go visit with her. But others are probably given misinformation, or they lose benefits, or they're just told to do something that they don't need to do. It causes a lot of stress, and I see that in my office, and it's really not a fair thing to do. And sometimes it all falls on the siblings as well. So one thing we don't want to do is kick the can down the road and think our other children are going to take care of that disabled family member. It's really not fair to them. And you don't want them to be resentful towards their sibling who's disabled. So some of the benefits of planning, and I'm trying to see what's on slide 1246. Okay, I'm doing it right. So one of the benefits of planning is provide financial security. So you need to think about money and where that's going to go. You need to know about all the means-tested public benefits, and I'll talk about what those are. Those are mostly, we're talking about Medicaid and SSI. You need to identify and start thinking about who the proper team is for your son or daughter. And that could include an attorney and different people as well, just to really put together a team. It's always good to have a team to help problem solve. What are some of your thoughts about housing? Who's going to be a good, strong advocate? So start thinking about who might be a really good advocate for your son or daughter. And just different questions to think about. Also about protecting beneficiaries from predators. And I think in terms of how vulnerable some people really can be. So my own daughter, I mentioned, has autism, moderate to severe autism, and she would be completely vulnerable from anybody, but even people who are a lot more independent than she is can still be vulnerable. They could be talked into something from another person. So we want to think in terms of protecting vulnerable family members and checks and balances. I would say that's a really core part of not just special needs planning, but also for estate planning. If we think about our own futures, someday we're all possibly in a vulnerable situation, so we need to always think ahead about having good checks and balances. And also about preserving assets, for other heirs, so other children, other family members. So planning isn't just about the disabled child, but also about other family members and making sure everyone is taken care of. All right, so first we'll talk about creating an effective plan for your loved one. So planning ahead makes all the difference. Who the person will live with. And I think it's important to think you don't have to have all the answers today. So the only ask is that you start thinking about your next steps and what you think you'd like. And I'm going to show you a way about how to document all that as well. Will your child need a guardian? Does he or she already have a guardian? How do you appoint your next guardian? Who are the players that you want to be involved? What are some of your dreams and wishes for your child? What are challenges? What are his or her wishes and desires? So it's good to just start thinking about that. You don't have to have all the answers, but you just want to start thinking about all that. So a great way to document information about your child or your loved one, or if you're a professional listening to this, it's just good information to tell family members, is we call this a Memorandum of Intent, but I think of it as an IEP for life. So think of it as maybe a Word document on your computer where you organize it in a way and you put down all that information you have in your head. So a lot of us have lots of information about kids and our loved ones in our head, and that information needs to be put down on paper so that someone else in the future will have that information. So you would put down information like phone numbers and contact, all that. That's pretty straightforward. But I also think it's important to put down what are some of your wishes and dreams, for your son or daughter. What makes a good quality of life? So for some people, it might be, I want my son or daughter to have access to social opportunities, to recreational opportunities. My own daughter loves amusement parks, so that's really important for her every year. So usually sometime in the summer, starting around January, almost on a daily basis, we'll hear about where she wants to go that summer. So those are things that are important to her. And I'd like to get all that written down and have that. So this is not a legal document. It's just getting information out of your head and putting it on paper. So a good rule of thumb is, or just a good way to proceed with this, is every year on your child's birthday to pull out this document and just update it. Put any new information, print it out, and have it ready where others know where to find it. Okay? All right. So another consideration to think about is money. So what do you think your son or daughter will be getting in the future as far as income, and what are their expenses going to be? Again, you don't have to have everything figured out, but it's just good to sort of see what the shortfall might be, because there will be a shortfall. If your son or daughter is getting SSI, off the top of my head, I think that's about $823 a month. That's not a whole lot. I'm going to talk a little bit about an enhanced version of SSI in a minute. Also, what are some of the living expenses the person might have? What about care assistance and personal needs, education, transportation, medical, food, all these other things? So start thinking about, the financial picture, what that might look like when you're no longer around to help your son or daughter. Okay, so this little chart here is not meant to cause any stress. It's just a way to start documenting information and start a starting place again. So again, I don't want to stress anyone out by looking at this. You don't have all the answers, but and this could be something that goes into the document that we just talked about, the Memorandum of Intent, or anywhere where you just start thinking, this is what I think my son or daughter will need in the future. And I can make any of these charts available to you. Just if you have my website, I gave it to you at the very beginning, I think. It's specialneedslaw.attorney.com. And if you, there's a contact page there, or you can call my office as well, 802-223-0600. I can give you some of these documents so you can print out, or I'll give you the digital version. You can fill them out. So more of that. Let me catch up on my notes page here, see if there's anything else I wanted to add to this. I think, okay. So Janice did mention that there will be an upcoming seminar on funding special needs planning. One great way to fund is with life insurance products. So Larry Hawley is going to be doing a presentation on life insurance. And that's a great way to fill in that big gap from what you might have or what your son or daughter might inherit from you to what they actually need to be able to have a comfortable life for the rest of their life as well. And I do want to mention one other thing about making sure you go to, if you go to a financial advisor, to not go to just any financial advisor. And I say this because as an estate planning attorney, I know many financial advisors, and I will tell you that very few know anything about working with special needs. Just this past year, I've worked with a couple situations where these are adults with disabilities that on their own went to a financial advisor, and they were put into products that they never should have been put into. And now they're losing benefits because Medicaid or Social Security discovered this financial asset. And to get out of those assets, it's going to be very costly without tax implications. So I encourage you not to just go to your local financial advisor unless this person definitely has experience with special needs. Again, you can call my office. I'm happy to give you some referrals as well. Okay, so next steps about getting a third-party special needs trust done. So I'm just going to touch on this right now, and then I'll talk more about it a little bit later. So in whole, special needs trust is a way to hold onto assets for the benefit of someone like Ben, a disabled person, and there's no limit as to what can go into it. And the best part is, well, there are two parts that are really important. One is whatever assets are in the third-party special needs trust do not count against the person for their $2,000 limit that they can have for Medicaid and SSI. So that's the first part of it. It could be as much money in there or whatever. And a trust can own investments. A trust can own a house. There's a lot of things a trust can own a business. But whatever's in the trust, as long as it was written properly, and that's the key. And I say that as an attorney who reviews lots of special needs trusts, that if it's not written correctly, that's going to present a lot of problems as well. The second big part of the special needs trust is that it really should be about the individual's needs. I mentioned earlier about my daughter that loves amusement parks. So in her trust, I put that she loves amusement parks. She loves to do different sorts of activities. So those are guiding information that I put in a trust because I want a future trustee to know that this is more than just Medicaid and Social Security and protection. This is about quality of life. This is the only assets that a person like Ben could ever have while still maintaining benefits. So this is really important for a lot of that. So it's called a third-party trust. There are different types of special needs trusts because the funding is from someone other than the person with special needs. If it's a person, if it's their own funding, then it's called a self-settled special needs trust. Okay. So what are some other things that a person with a disability could do? And of course, it depends on what the person is able to do on their own. So one is that they can sign an advance health care directive, and that, of course, is to have an agent step in to make health care decisions when that person is not able to communicate what they need. Incidentally, this is important for anyone who's over 18 to do an advance health care directive. And picking an agent could be a spouse, it could be a family member. It's usually, I would say, for most people, it's a close family member, or it could be a close friend. It's someone that you would trust to step in and say, Ben would not have wanted to do such and such, or what have you. So that's a very important document to do. Another document that a person could do as well is a power of attorney. And for both of these documents, whoever is the principal, so the person who this is for, has to have enough understanding of what these documents are for. So as far as the power of attorney, I would say that for anyone over 18, that is probably the most important document that you can do. Regardless, nothing to do with disability, actually. So a power of attorney allows an agent, again, it could be a spouse, a family member, to step in your shoes and do transactions for you and sign documents for you. And it could be done today because of convenience. So for example, I went to the DMV the other day. I could take the power of attorney I'm an agent for my husband and sign for him, so we can do it for convenience. Are also really important if a person's incapacitated. So make sure you all take care of that. A few years ago, I want to say 2012, I wrote a Bar Journal article on alternatives to guardianship, and that includes advanced health care directive and powers of attorney. I can't remember the name of it. I can't remember the name of it. It's been a long time. So I will mention now, and I'll mention this at the end, I can send information on any questions that we don't get to today, and also some of the articles. If you go to my website, specialneedslawadttorney.com, and sign up for the newsletter, then I can send out this article to anyone who signs up on that as well. So for some people, advanced healthcare directive or powers of attorney is not realistic. That would include someone like my daughter. It might include someone like Ben. And for some of those people, we might consider guardianship. So there are different types of guardianship, and I'll get into that. And, parents are typically the legal guardians, but that's not always the case and not always the best idea. And this is a court process as well. So these are some of the different things that families can start thinking about as far as what to do with, other ways of helping a person with a disability. So we're going to get to the very exciting part of understanding public benefits. Yay. Okay. So on the left are means-tested public benefits, and that's what we're mostly, and that's what we're mostly concerned about for special needs planning is the means tested. And by means tested, it means these are poverty programs. So SSI is a poverty program. Medicaid is a poverty program as well, and it's not available to everybody, but just in certain situations. So that's what we're mostly concerned with. However, there are different benefits as well. Entitlement public benefits include SSDI, and SSDI is different from SSI, and sometimes there's confusion with those two. SSDI is when someone somewhere pays into the system. So the person might have had a work history where they paid into SSDI. And Medicare is related to SSDI. If a person gets SSDI, they get Medicare. And also another entitlement that everyone is aware of is Social Security retirement. That's an entitlement benefit. So, and by entitled, it means that someone paid into the system somewhere. So that's how a person gets into those. Sometimes a person can get SSDI because they might have a little bit of a work record, or there's a different way of getting SSDI that I'll talk about in a second, and SSI. They might have a combination of both. And some other programs are Section 8 and veteran benefits as well. Okay, so let's talk about SSI. So to get SSI, that's a poverty program. So there are two different tests with that. So actually, I have them both in reverse. The first gate for SSI is the financial. So in Vermont, and I imagine the same in different states, there are different field offices. We have 3. We have Montpelier, Rutland, and Burlington. They're Social Security field offices. And they will take the initial application. It's all done online now. And they will determine if the person has the financial eligibility to get SSI. So they can't have too much money or assets, and they can't have too much income. Once that person meets that criteria, then it's sent over to Disability Determination Services, and that's in Waterbury. My husband happens to be one of the adjudicators there. And there is a longer, more complicated process of determining if a person is medically disabled according to Social Security rules. So not just disabled, everyone who's disabled, obviously many people are disabled and they work, they're able to do a lot of things on their own. So we're looking for people who are disabled by Social Security rules, and that really depends on what the alleged disability is. It could be a physical, cognitive, mental issue. Okay? All right. So what is SSI? It's a monthly payment. And right now, this is just off the top of my head, I think it's about $823 a month. And the amount might change. I think last year was like $802, or maybe a year before, I can't really recall. Not always great remembering numbers. That's not a whole lot of money, but it's what it is. And Vermont actually supplements the federal benefit. I think might be like $45 a month is Vermont's portion of that. So the federal benefit maybe $775 or something like that. So it's not a whole lot. Now, SSI is interesting in the way it works. So first of all, in Vermont, if a person's eligible for SSI, they automatically get Medicaid. So that's really, really important. And SSI is really sensitive to money that comes into a person. So if a person gets gifts, or if they're getting free rent, there's no such thing as free rent. If they get anything, then the SSI amount will get reduced. So one thing that's important to know about is if you have a son or daughter who's 18 and you applied for SSI, if they're getting anything less than that 823, then chances are that the Social Security is just assuming that he or she is getting free room and board. So you can do an agreement. I can prepare that for you. You can do that. Try to do that yourself if you like. And with a rental agreement that you show to the Social Security office, that would show that that person's fair share of room and board, the person can then get the full $823. But then you're now the landlord, and you do have to cut yourself a check if you're his or her guardian. Cut yourself a check as landlord to pay the rent, and you need to do that every month. But it's without doing that, the person will always get a reduced benefit. Also, it might get reduced if, as I mentioned, if the person gets gifts. Obviously, if they work, it would be less as well, because that's taken into consideration. So it's SSI. So here's just I mentioned earlier about Social Security determining what disability means. So this is the technical rule behind that, of what SSI definition is. So it's actually pretty complicated, and it does take a while to get that determination out. So the resource test for SSI, I mentioned there are resources and there's income. So $2,000 is all that a person can have in resources. So that would be just about everything unless it's in the list below. So what are exempt resources? A home of any value, a car, furniture, clothing, some personal items. Now, this means, and these are coincidentally the same rules that apply for nursing homes. So if there's a single person about to go to a nursing home, it's the same test that's for Medicaid. So it's the same rules for Medicaid as well. So even though a disabled person can have a house worth $500,000 in their name, it's not always a good idea. So it just depends on that person's individual ability as well, because they may not have the ability to manage that. So it's not always a good idea to do that. I'm going to go a little bit quicker because I'm running out of time. So I mentioned this earlier, in-kind support. This has to do with reducing that SSI check because of presumed free room and board. So I'm just going to mention this quickly, and that is, I mentioned earlier, SSI is about $823 a month, but there is a way to get an enhanced sort of SSI benefit, but it's not really SSI, it's SSDI, and it's called Childhood Disability Benefit. So I encourage you to write this down and look into it. You can get more information. So it's basically a way for someone like Ben or your son or daughter to at some point get an enhanced benefit because they're able to tap into their parents' work record. It could even, I think it might even apply for step parents, I'm not positive. So instead of getting $823, they might get $1,000 a month, or they might get more. But there are some hurdles to cross for that. And one is the person would have to, you'd have to show some sort of proof that that person was disabled before age 22. That's why it's called childhood disability, so from childhood. And so I always recommend keeping evaluations like IEP evaluations, Social Security evaluations, guardianship evaluations. Hold on to those documents in a safe place, because someday that your son or daughter may be eligible, and that's when parents are either retired, disabled, or deceased. They can get up to 50% of whatever the parent is getting without taking away from the parent. Or once a parent is deceased, they can get 75% of the value. So it's quite a big difference. So Medicaid, as you know, is very important. I would say for most people, SSI is really important, but for most people, Medicaid is the big one, because that's a lot of money and a lot of great care and services. And the states vary widely with what Medicaid covers. So what we cover here in Vermont, it might be different in a different state as well. And so states do have some leeway to decide who gets Medicaid and who doesn't. Okay, I'm going to go a little bit quicker here. Okay, so let's jump back into, now that we know more about government benefits and their importance, to talk more about special needs trusts. So as I mentioned, it preserves SSI and Medicaid, and it's also for deciding who the team members are and writing some of that down. And I'm way behind in my notes here, just to make sure I don't miss anything important. Okay. All right. So one of the important decisions to make with a trust is who will be the trustee. So the trustee is the person or persons, or could be a corporation, like a bank, who makes the managerial decisions of a trust. That is a huge, huge important role. Initially, when, if it's parent, usually the person who sets up the trust, typically the parents, could be grandparents, will name themselves as trustee, and that makes a lot of sense. Often the parents will name themselves as trustee. For the most part, a lot of trusts aren't funded until after the parents have passed away, and then usually through life insurance or something like that. So there's not a whole lot of work to do, but at least it makes sense they have the trust set up. If they want to make any changes, they can do that, and it's much easier. But it's good to name a successor trustee. So I'm going to give you all your options for successor trustee because it's a huge decision to make. And this is something you should never walk into an attorney's office and say, I've already made this decision, because chances are I will talk you out of it, but or not. Maybe you have a really good decision made on that. So the first option, I think of them in 4 groups. So the first option is a corporate trustee, and that's like a bank or an investment company. I'd say the benefit to a trustee like that is that you have they're professional trustees. Their bank or investment company or probably been trustees for many, many years and have a lot of experience. They have all the fancy software, and they know how to do the accounting very well, and probably a lot of other benefits as well. And they're impartial, so not a family member. I'd say the negative of a corporate trustee, a lot of my clients do go with corporate trustees, especially on the non-special needs side. Is they don't have necessarily a lot of expertise on special needs planning. So some of the trustee departments might be located in, I don't know, St. Louis, Missouri or something like that. The other part is that they don't necessarily, I think there's a conflict. There's always going to be an issue with any trustee you pick, just so you know that up front. So one of the responsibilities of a trustee is to be what's called a prudent investor. So there's some assets, they need to make sure they're invested and not just sitting under a mattress or in a checking account. And one of the things, if you went with ABC Bank and say what ABC Bank is, they would invest the funds with ABC Bank and they probably wouldn't go elsewhere. And that can be a little bit of a challenge because they're not necessarily monitoring themselves very well, I would say. The other option is a individual professional trustee, and that's like a lawyer or a CPA. Those are, I think, the typical individual professional trustees. So it's a service I provide, but like I said, other attorneys and CPAs do that as well. I would say one benefit to that, it's a person that you would meet and know, and they would have a special expertise related to this. Also, they're impartial, just like the corporate trustees. And the other one is, as far as like the assets, they would probably have the assets. I usually would use, probably Edward Jones or maybe Morgan Stanley or someone like that. But if I'm not happy with what they're doing, I would move, the assets elsewhere. So that would be, I think there's a little bit more distance there. The downside is that if it's one person, then you have to think about who is their backup. So if that person retires or passes away, and I always say you could always pick a corporate trustee. So the third choice is maybe like a friend that you might know that has maybe a financial background or legal background that might do this for you. And sometimes there's a case like that, and I think that's great to have. Again, they're impartial. There's no conflict of interest. And the fourth, and usually the worst choice, is to have someone with a conflict of interest. So this is typically siblings of the person with a disability. With rare occasion would I like to ever put them as trustee. Trustee is a lot of work to do. I'm not sure if I have a slide on that. I think I do. About all the different responsibilities. A great role for siblings is to be a trust protector. So they could kind of keep tabs on what the trustee is doing and be sort of a co-advocate with that sibling. So trustees' responsibilities: managing the assets, distributing trust accounting, tax returns, taking phone calls, lots of phone calls. And this is, and also they're personally liable for any mistakes that they make. So it can put siblings in a real tough situation if now you have another sibling calling and asking for money all the time, because that's what happens with special needs trusts. You have lots of requests for for distributions, for, an $800 computer screen, or all these different things that you as a trustee have to think, well, wait a second, this isn't going to last if we're just going to be throwing, money all over the place. The trustee's got a big responsibility. So other arrangements that definitely are not recommended is on outright inheritance. So if we were to give Ben, if his parents just went to, drew up their own will and said, okay, Ben will just get 50% of what we have, then Ben loses his benefits. Also, as I mentioned, I review a lot of different trusts, and if it's not a special needs trust, then that also would count against Ben as well, so he could lose benefits. And on that note, I will say that it's not unusual for me, again, a few times a year, I tend to get a few different situations that always come up, is if someone does have a trust that was written up either because it wasn't a properly written special needs trust or it was a different type of trust, where now we have Ben, for example, named as a beneficiary. It may be years later that Medicaid or SSI discover this document. They'll say, wait, this is not a qualifying trust. Therefore, Ben was never eligible for SSI and Medicaid. Therefore, not only will he lose benefits, but now he has to pay it all back. And that could be years after receiving benefits. So it's a really horrible situation to happen. So make sure if you're going to do it right. We obviously would not want to disinherit Ben, and we don't want to just leave two siblings for lots of reasons. Again, one is, and that's sort of a common thought is like, well, why don't I just leave whatever I wanted to leave to Ben to his sister, sibling, right? Sibling. And there are lots of reasons for that. One is that she's not under any legal responsibility to help her brother. What if something happens to her? What if she has trouble with creditors? What if she wants to go to college and now she's has too many assets? What about her spouse? How does her spouse feel about this? Is there a chance that her spouse is going to be saying, wait a second, your brother's fine. Why don't we keep this money? What if she gets divorced? And I think the bigger question is asking that other child to really commit Medicaid fraud. So I'd be really careful with that. So if you have a situation where your family member who's disabled has assets already that's in their name, so that wouldn't be good for a third party. A third party special needs trust that I've been talking about is a planning tool, mostly for parents or grandparents that wish to leave for their son or daughter some assets at some point, or to point life insurance to. A first-party trust or self-settled special needs trust, that's if there's a situation where somebody gets some sort of a windfall. And it might be for most common reasons are parents didn't do any planning at all, so now they're left with a situation where they're sitting on a little bit too much and now they're losing benefits, and that's kind of a crisis situation. Or the other one is for like an accident settlement. That's sort of the two common reasons why we set up a self-settled trust. So for a lot of reasons, they work out the same. They're more expensive than setting up the third-party trust. But the biggest drawback is that with a third-party planning trust, the parents that set it up might say, okay, someday after Ben passes away, I want what's left to go to his children if he has children, or to my other children, or to charity. Well, you don't get to do that with this other type of trust. So once assets are already in that person's name, for, like I've said, for a first-party trust, then whatever's left first goes to the state to pay back all Medicaid. And that's from the time they started school. So most people fall out of their chair when they hear that. So it's nice to avoid that and try to, keep whatever you have in the family. So let me talk briefly about the ABLE account. I have lots of notes. I have an article a few years ago from the ABLE account. So this came up as a reaction to College 529 accounts where people were saving money, had some tax benefits, and parents were saying, well, wait a second. my son or daughter's disability is so severe they'll never go to college, and so they wanted their own. And what turned out after the legislation was passed was something not quite as great as the College 529. So it's got some drawbacks, but definitely has some great reasons to use that. So so the ABLE account it kind of works like like if you ever sign up for like an online bank account. So it's a setup a person can do on their own without an attorney. You can look up ABLE accounts, and some states let you jump onto theirs as well, and you can shop around and see that. So it's like an online account that you add money to, and it works similar in that whatever's in there does not count against the person for Medicaid and Social Security. So that's a great part of it. It's only for people who are disabled before 26, so that leaves out a lot of people who may have a disability that wasn't diagnosed until much later. Anyone can throw funds into this as well. I don't recommend that parents fund this, but I can mention that in a sec. And what else can I tell you? Oh, so the challenge with this, with an ABLE account, is that say parents decide that instead of doing a special needs trust, they'll do an ABLE account, save some money. Well, what happens, whatever's left in the ABLE account after that person dies goes to pay Medicaid. And that doesn't matter who funded it. So even if the parents funded it, where with a third-party trust, that could have, whatever's left could have gone to siblings or the family members. Now you're just giving the state a gift. So I don't recommend it for a planning tool for parents or grandparents. I do recommend the ABLE account. I found some very great uses for it. So for example, if there's a really, really small estate, parents die, there's not a whole lot of money in there, then I'd say, yeah, put it in an ABLE account. It doesn't make sense to go set up a self-settled special needs trust for that. But another great use for it is when you have an adult who's working, he's maybe on SSI but still working, getting some money, and he's starting to bump up against that $2,000 limit. So they can put some money into the ABLE account and be encouraged to work and keep saving some money. Now that person, it's his own funds. What does he care if at the end of his life that goes back to Medicaid? It's not going to really matter. So so pros and cons with the ABLE account, but it's really a great tool, and they do work really well with special needs trusts as well. So guardianship. I wish I could ask a question. Okay. I wish I could ask if everyone wants to hear about guardianship. So I'll tell you just a quick information about guardianship. So at 18, individuals are always presumed to have capacity to make their own decisions. If the person doesn't have the capacity to make their own decisions, or you're really concerned they're going to make really bad decisions, person can approach the court and seek guardianship. So there are two different types of guardianship in Vermont. There's voluntary and involuntary. So voluntary, I would say that's with a person who perhaps maybe has, maybe some mental health issues, or maybe a certain type of disability that they're personally aware of their need for help, but they want to be in the driver's seat. So they can fill out an easy peasy petition with a probate court and say, I want my mom or my friend or so-and-so to be my guardian. And it's pretty straightforward. There will have to be a hearing with the judge asking lots of questions. And that could be done at the court, or the judges also, they like to travel, so they'll come to a person's home as well. Involuntary is for people like my daughter, who just, she's under guardianship. There's no way she could have done the voluntary guardianship. She just doesn't have enough awareness of that. So we had to do the involuntary petition route. So my husband and I are her guardians. And, there are a lot more safeguards involved with that. So an attorney gets appointed, and that's free. That doesn't cost anything for that. An evaluation is done, and it's just more safeguards to make sure that this person really is in need of guardianship. But another group of people that also sometimes fall under this, or maybe you have someone who could, if they wanted to, approach the court and say, I need help, and this is who I want, but they really refuse to. And there goes my phone. You throw Thank you, Janice. So those are the different types of guardianship. All right, so what are your marching orders? Is definitely work on that memorandum of intent, the IEP for life that I mentioned earlier. So start working, get yourself a Microsoft. And I have a template floating around that if you, send me an email or, again, get on my list, I can send you that. Make sure you take care of your own estate plan as well. Think about your own needs and needs of your other family members and your spouse and all that. So don't forget to take care of yourself and your own needs. Think about a special needs trust. Again, that's not necessary for everyone. There are different types of documents as well that might be more appropriate, but it just really just depends on your child's individual needs. The financial, again, you're going to hear from Larry Hawley coming up in a couple months, I think, about life insurance. I give you his contact if you like. Well, I have it all written down here. It is on February 5th. Yes, so you'll hear about that then. And also about coordinating all the beneficiary designations. That's an important part of estate planning as well. Let's see if I think I have a quick question that I wanted. I have a few questions. Oh dear. All right. So how much money should you have to make a special needs trust worthwhile? Again, I think the better way to think about that is that whatever you don't have, if there's some sort of a gap, that you really look into life insurance. That's a great way of funding a special needs trust. So I would say most people would think about it, maybe $25,000, more than that. I'd say more than that, it would start to make a lot more sense, especially if you have the possibility of other family members chipping in. It's a great idea to let family members know, if grandparents are still alive, to let them know about, hey, I'm setting up a trust for my son or daughter. Here's how you write the check, sort of thing, so they can build some of their estate planning around that as well. So that's an incentive. The younger that you can get it done, the better, because more people know about it. And there's some other quick questions I'm going to look at. So as far as frequency of meeting with an attorney, I usually will send out a letter once I do estate planning, whether it's special needs planning or any estate planning. I'll send a letter every 4 or 5 years and say, do you have any updates, any changes that you'd like to make? And come see me if you don't. Has any situation changed? Maybe a spouse passed away and now we're down to one parent for that child. That really changes a lot. So if you know of someone who's a single parent, that is really critical they take care of this, because they're that last line before, a lot of big significant changes could happen. So as far as do-it-yourself trusts, I say that if you can't afford to see an attorney, then you probably don't need to worry about trusts anyway, because it goes back to the question of, if there's not a whole lot of funding there, then maybe it doesn't make a lot of sense. But if you do have, and what that magic dollar is really depends. So I like to think in terms of, this is for estate planning in general, is if we spend a lifetime of working and putting money aside, we have a house, we have some things, that's not the time to be, well, I'm just going to be trying to do this on my own, because that could be really disastrous. There's always a lot of cleanup work that I do every year, and I have to tell you that it's really, really tough. I'm sorry. So as far as setting up a special needs trust, so they're very individual to each child. So it's important to set them up separately. If we have more than one disabled child, we wouldn't put them in the same special needs trust, because what that trust is for that one beneficiary, just to make sure that they're all set and that trust will travel with them. And to set up a third-party trust, it's probably anywhere, I'm not sure who you'd go to, I would say between $2,000, $2,200, $2,500, something like that. So roughly the equivalent of, 3 SSI checks is how I like to think about it as well. Let's see, just reading other questions. All right, I would like my son. Okay, so a question about the home. So other trusts that can be done is like a family trust where you could put a home in the trust. If you're able to do that, that's wonderful. But say you don't want, you have more than one child, and so you could have other children be the owners of that house. So if it's ever sold or anything like that, they can all benefit from it. But then we can give that disabled child perhaps a right of occupancy so they can live there as long as they need to and with a caregiver, so that you have peace of mind that that son or daughter will always have a really comfortable place to live. But you're also being fair to the other children that you have. So you don't have to just do everything to one. There are a lot of different ways we can work with this as well. Okay, so about setting up a trust. Well, I always say, let me see, I'll read the question. We have a situation where the individual with special needs will be inheriting the house from the private guardian. The plan is the home would be sold and the individual would get the money. When should we plan to set up a trust? I would say always the sooner the better. I have lots of trusts floating out there that with maybe just a few dollars in them, just kind of waiting. And the reason is to get it done sooner rather than later is if those funds go directly to that person during those months he's sitting on any type of extra cash, he could lose benefits. So I would have it set up sooner rather than later, and just to make sure that it's all taken care of. What else? Okay, so another question. We don't have guardianship for our daughter who has an intellectual disability. Will she be asked to sign all the paperwork to establish the trust? What type of powers of attorney would we need to sign on her behalf? Oh, really good question. So a few documents you can't ever sign for someone else, and that's including your own spouse. You can't ever do, or for your child or for anybody else, you can't sign a power of attorney for someone. You can't do a will for someone else. You can't do an advance directive. Those are very personal. So even for all of you, it's important to do that while you can do that. Now, if the person does not have guardianship, doesn't matter how disabled they are, their signature is a signature. That means they're held, if they make an agreement with someone, they can be held legally responsible for that as well. So that's really important for that. Okay, so make sure if you'd like to get more information, sign up for my newsletter. I have a couple workshops coming up. I have a state planning workshop coming up in Northfield December 4th, Waitsfield December 6th, a special needs law workshop coming up in Middlebury in January, and then I think another one in White River Junction. So please sign up for my newsletter, and thank you so much.
I'd like to thank everybody for joining our webinar today. We're going to save this on our website, and we're also going to upload it to our YouTube channel. You are going to get a short survey after we close here. If you could just take a couple minutes to fill that out, that really helps us out. If you want any kind of additional information, feel free to visit our website, which is vermontfamilynetwork.org. And we always would like to hear from families with any kind of questions you might have. And so feel free to call us at any time. Our toll-free number is 1-800-800-4005. And have a good day. Thank you.